I am joined by JP Kemp, Kemp and Kemp out in Las Vegas. And we're going to be doing your guys' console today. Before we get started, I'm going to turn on the Microsoft Teams transcript function just to help us with note taking, since it's just going to be us in the Teams transcript. So let me do that really quick, and then we can go ahead and get started. Okay. All right, great. All right. So we've got the transcript started. So we got the documents. And who is it Miss Lee, Mr. Lee, who is the professor? Oh, okay. Oh, okay. Okay. Um, okay. Okay. Uh, okay. 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 Right. Gotcha. Okay. So husband and wife, are you guys uh uh how long have you guys been married? Okay. Okay. So the and I only say the consult today is there's an extension of attorney-client privilege to the consult. That's typically with one-on-one with the individual who is seeking the consult. However, I typically a lot of states have what's called spousal privilege, where it's and I don't know what it is in
No, we're
Nevada.
good. We're
Okay.
good in Nevada. It's
Okay.
the spousal privilege will cover this
Great.
just fine. Yeah.
Great. Okay. So we got your documents, and including the president's decision, your request for reconsideration. Very helpful PowerPoint presentation. Um, uh, and the case summary write-up that you provided. Um, and so I have a couple of preliminary questions before we sort of get into some of the details about what happened, and because I have a lot of questions about that and making sure that I am fully tracking what is going on. But just in terms of procedurally, have you guys filed any sort of charge or complaint of any kind with the EEOC or the Nevada Equal Rights Commission or anything like that? Okay. So when you got the decision after the request for reconsideration, that is the most recent thing that's happened. Is my understanding correct? Okay. Yeah. Right. Okay. Okay, yeah, that it looks like the document, the client case summary that we have. Is that the same? It looks like the same thing. Okay. So, from what I have read and seen, uh, it seems that Mr. Lee, you were hired in January of 22, and you became tenured effective July of 2025, right? And I know that tenure comes with certain additional protections and things like that. Did you get any sort of additional employment contract or employment documents or anything like that after you became tenured? When you were first hired in January of 2022, did you sign any sort of employment agreement or contract or anything like that?
They, I think they typically do a new contract every year. And if you're a
Oh,
tenured, they have to, well, actually, once it's tenured, I'm not sure, but I know before tenure, they do a new contract every year. And sometimes when they say we're not going to renew you, so that you're not going to pursue, if they're denying tenure, they give you a terminal year, and it runs from July 1st to June 30th, is the year that it runs on. With most, like the cases we've had with UNR, UNLV, that's how it works. I would assume that Great Basin College is similar to that, being
okay.
part of NSHE. Once it's tenured, though, I'm not sure that they do that the same way. I think once you're tenured, they have to have some sort of good cause, and it's going to be probably set forth in the NSHE code. So I guess the real question is, what are they saying are the policy or procedure violations that they allege to have you to have committed that supports your being terminated from a tenured job?
So it looks, and just for everybody's awareness, it's we got the documents. I don't know if someone on our end had sent those over to JP yet or not. It my
I
under
I got some emails from Lee's this morning, but I haven't had a chance to go through them.
so
It
the
looks
my
like
yeah, the it from my understanding, the layoff came with there was a decision to uh essentially, even though I don't know, obviously the difference between deactivation and elimination is something that I imagine is going to be discussed, but effectively there was a decision to deactivate or uh you know uh for a period of however many years the computer technology department at the college, right?
right. Okay. Yeah.
Do you, I apologize.
My my audio has gotten bad. I'm sorry. I don't know what happened, but all of a sudden, right in the middle of her speaking, it got real muffled on me. So I'm gonna see what I can do if it's
I I have a question that for you guys. Uh the difference between deactivation and elimination. So I looking at the documents, I agree the initial documentation when you're talking about the recommended course of action that I saw in a document dated from December 2024, I think. Um was talking about deactivation, the deactivation plan with the reactivation in however many years, 5 years or whatever. Um, if they're the student enrollment and other factors, changed or increased, what have you. Do you what is the course? What typically happens to faculty when it comes to deactivation? What's the difference between that period of time where it's a temporary deactivation? um, I'm assuming that the course, the impact to the course work is still the same, right? In terms of the courses in the department that's proposed for deactivation is still um, not being taught or being reduced, or I guess, do you guys know sort of what the distinctions between deactivation and elimination are? Okay. So the deactivate, so if there's a deactivation temporary and the plan is to sort of reassess the viability of the program in 5 years, during those 5 years, the professors who would are impact could be impacted by the program's eventual elimination, uh, they would still be teaching during those 5 years. Okay. Okay. Yeah. 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 That's what I was referring to. Yeah, earlier. Okay. So So the other my so am I understanding correct that the department computer technology department has two professors within that department? It would be you're the only tenured professor, Mr. Lee, right? Non-tenured. The non-tenured professor, what do you know what their race or national origin is? Yeah, right. Okay. Okay, so American, is she white, Caucasian? Okay, okay, okay. When was she hired? Do you know? Okay, so do you know why she hasn't been granted tenure already? Because it sounds like she started before you, and then I'm curious if there's any particular reason that you guys have heard or are aware of that has kept her from obtaining tenured status. Uh, gotcha. Uh, Gotcha. Okay. Right. Yeah, yeah, yeah. I'm just trying to see, yeah, the distinctions between you guys. Okay. Okay. So what is the impact of this elimination on her uh position? I'm assuming she's gonna still be retained. She's not getting laid off. Right. Okay. Um, so all of the courses that you were teaching, Mr. Lee, um, are essentially being eliminated. Is that is that right? They're not the courses themselves are not being eliminated. It's just the department and the degree uh program. Okay. Okay. So what? Um, okay, okay. So are yeah, no, well, my question then becomes is uh why the courses that you're teaching, why they're not being kept for you to, I don't understand why you're not being kept on to teach those courses. Mhm. Okay. Oh, I see. And that's what these numbers are on the screen. The load course, those are the numbers of projected. Okay. So are so uh, and maybe this is part of why it this doesn't make sense to you guys, but for me, I'm just any of these courses, Mr. Leon here, were you responsible for teaching any of these courses, or are these courses that you're qualified to teach? Okay. Oh, okay. But the other ones, data 110 and up, you're qualified to teach these. Okay, gotcha. We're at the time that you learned or uh that you were being laid off and the program was being deactivated, were you assigned to teach any of those courses at that point? Yeah. Okay. So you're only in terms of like if you're a full-time teacher, you have to only teach a full-time course load, which is around 15-ish hour course hours. Is that right? So currently the chair, the non-tenured professor in your department, she's essentially teaching double those. Okay. And right. So I know that uh we had the letters and the committee's recommendation and things like that to the your request for consideration hearing. When you raised this point in the hearing, did you what was the response from the committee members present? Did they give you any particular response to that or any reason why they couldn't sort of balance out the course load? Okay. 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 Um, so what sort of going through the legal issues to just that you guys identified here, the discrimination aspect. Is there anything else other than all we've went the things that we've went over so far that makes you guys suspect or think that there could be some discriminatory animus at play here, and the fact that you're a Chinese national uh, motivated, the layoff decision as opposed to an alternative course of action to retain your employment. And it's okay if there's not anything. I just want to be clear. I just want to know if with interactions with any of the professors or the committee, did anybody say anything, make any comments to suggest that your national origin might have influenced the decision or that people may view you differently or negatively because of your national origin, anything like that? Okay. Mhm. Okay. That's fine. Do you know, because you mentioned that your performance evaluations for the past several years were excellent. Do you know what the non-tenured chair's performance evaluations were by chance? Do you know if they were the same or worse, or if you had heard, even if you don't know for sure, if you had maybe heard that from somebody that she, did not meet, receive an excellent performance rating any given year, or anything like that? Okay. Yeah, I was just curious. Sometime, depending on the size of the college, some, teachers, professors can sometimes, chat informally, and, maybe it was a matter of somebody was talking about something that you overheard. That's kind of what I was curious about, but it's okay if not. Um, so when is your I guess termination? When is the official date that your employment is supposed to be terminated? Like the effective date? Okay, all right. Um, and so let me see here. I want to make sure that I uh, am not. So on the breach of contract claim, it would be very useful if you guys could like take a look and see if you maybe can uncover. It doesn't have to be, you can send it to me after the consultation. Um, but if you happen to find an employment agreement or employment contract in your pre-tenure days, in any sort of documentation that you may have gotten at the time that you obtained tenure, even if it's not an agreement, if any kind of notice or other correspondence just confirming or congratulating you, anything like that. That, yeah, that would be helpful for us to assess the breach of contract claim. Um, you know, there's definitely like, you're correct. There is some pre-termination notice requirements uh, under the 14th Amendment. But when in terms of breach of contract, that one's going to require a focus on more of the specific terms associated with your employment. Um, and any sort of documentation discussing that is going to be useful for that assessment. Oh, okay. Mhm. Okay. Yeah. Great. Yeah, because I mean, when you're hired onto a position, I mean, you know, you could be signing a ton of different documents, right? Uh, when you're first onboarding, things like that. And so, particularly if the pre-tenure years required contractual agreements each year, that would be something useful to have. It may not, but it's, that's something that you have. Um, you know, that is definitely something that we want to take a look at. Um, the uh, the Nishi. Oh, no, no. I apologize. I didn't mean to cut you off. What was your question?
Well, yeah, I think that 233B does not apply in this because you're not dealing with an administrative agency. You're dealing with the system of higher education. This is basically it's dealing with the university system. So for this type of action, I mean, if it was if it was a workers' compensation claim or something that was going through the labor commissioner, then you would be looking at 233B. But I don't believe that that's correct. I think what you do is you have to basically sue them for breach of contract or for some sort of civil rights discrimination type of violation. So so it would be like a breach of contract kind of case in court. So that not really judicial review of an administrative decision, which is what 233B is. It's more about filing a civil action for breach of contract or for discrimination based on national origin, for example. No, so not a writ of certiorari or mandamus would not be the correct thing either because you have other you only seek those when you have no other legal avenues that you could pursue. And here you could pursue a direct action for breach of contract or potentially for discrimination under the statutes. A writ of certiorari, a writ of mandamus, more to the point, is to order the university to do something that the law requires them to do. And here I think they're disputing what the law requires them to do, and so it's going to take an interpretation of the contract. So a writ petition would not be the right way to go. It would be a lawsuit filed, by a complaint in court. Yeah, correct. Because 233B that arises a judicial review action would be if there had been some sort of a administrative hearing, which they do sometimes with respect to the public employees in Nevada. I don't know about it through INSHE, but like I've had people worked for, say, the Department of Corrections, and they've challenged their termination through a hearing officer program that the statutes have. So you can file an appeal of your termination. You have to do it within a certain period of time, and it has to go through this hearing officer. And then once that hearing officer renders their decision, that can then be appealed to court on judicial review under 233B, but not with a tenure issue like what you're looking at. That's more for like when somebody has been accused of, misconduct. Usually you would sue the state of Nevada. It's like they style it state of Nevada, XREL, Nevada System of Higher Education. Sometimes the Board of Regents gets included in those, and um, because that's who basically runs the entity. There's a section in NRS that talks about when you sue the Nevada System of Higher Education and some other state agencies as well. But that's how we've seen it styled in court cases. Is State of Nevada, XREL, Nevada System of Higher Education on behalf of the uh, on behalf of Great Basin College. It's something along those lines. I'd have to look it back up. I don't that's best of my recollection off the top of my head.
Well, I mean, for me, the breach of contract claim is interesting. But before I can sort of give you my full opinion on that, I want to either see what other, agreements or documentations prior to, the issues here, if those are in play, and review those within the context of what's happened. Um, because that assessing a breach of contract claim with, prior agreements or employment expectations, things like that, it influences the assessment of, whether or not there was a material breach, what the contract was, what the terms were, and whether or not there was a material breach. Um, for the procedural due process, that one I would need to do a little bit more research on, to be honest. Just from what I see, from what because the procedural due process, really the biggest, you're looking at pre establishing you have a property interest, then you're looking at whether or not you have pre-termination notice and a right to respond. Um, and it seems so far, there are nuances in that, but like in terms of like your generic big topic points, it seems just from looking at it that one may be a hard claim to prove. And I mean, what you're looking at too, and with all of these claims, is what your remedy is, what your relief is if you prevail. And on the due process claim, I mean, really the relief you would be looking at is just to sort of have a do-over or have quote unquote proper notice and a proper opportunity to respond to a notice of termination. Right. So that one I would say, of all the potential actions, that one to me is the least compelling. Um, the code violations, I can't speak too much on that because I'm not licensed in Nevada. But I think that could be relevant to the breach of contract claim, depending on whether or not part of the terms of your employment and the terms of uh, sort of the understanding of expectations to follow and apply those codes strictly when it comes to tenure employment. Um, you know, there's a way that those could be considered contract terms, but it's hard for me to know, or for me to assess that without sort of getting the full scope of what documents are there, that apply to your employment terms and employment expectations and understanding between you and the university. Um, the discrimination claim is going to be, uh, that one is interesting. There is going I think that it's going to be hard to use the non-tenured professor as a comparator. And what I mean by comparator is when you're looking at a similarly situated employee in terms of discriminatory actions. So if you have, if you're the individual who is subject to termination, um, you know, what a court might be looking for in terms of comparator employees might be another tenured professor rather than a non-tenured professor. And it's, to me, a lot of times it's legalese and it is a difference without distinction, so to speak, or a distinction without a difference. But courts, federal courts have been pretty consistent on, if you're going to have another employee to compare in terms of assessing whether or not an act or a decision was discriminatory, the employee that you're comparing to has to pretty much be not identical, but I mean pretty damn close to it, really. So the fact, the other points, her being under 40, her being of a different national origin, that is useful information, and that is information that you can use. But the fact that she is a non-tenured professor, a court may not view her as a appropriate comparator employee. Now, that doesn't mean you can't prove discrimination. But the other stuff that you would need to look at is, because when you're looking at discrimination, right? What you're really looking at is the individuals who are responsible for making the decision, right? What were their motivations? And so here, who was it, one individual who was ultimately responsible for the decision to subject you to a layoff, as opposed to looking to reassign you to courses that you were qualified for to teach, right? In accordance with the Nishi codes. Was it multiple people? How many people? Who were those individuals responsible for that decision? What were their protected characteristics? Their race, their national origin. Are they familiar with your protected characteristics? And were they before they made the decision? So those are questions that I don't think that I think it would be hard to get answers to, even for you guys, without, right, doing a little bit of fact finding after you're already in court. Looking at the circumstances as you've explained them to me, and as I understand how the course of action typically goes, I agree. It seems like they are navigating differently than what the code is saying. It looks suspicious. I'm not gonna, say otherwise. It seems odd that if you're a tenured professor, you're qualified to teach all of these courses, and assigning you to teach these courses would not lead to having to reassign or remove another professor. I mean, to me, that is the biggest question: is why that wasn't done, why the decision to not pursue that avenue was made. It could be discriminatorily motivated. The difficulty is that it's hard to say. There's not a lot of evidence available now to say it was outside of they're straying away from what the standard practice appears to be. Um, so that's my general uh and I mean bad faith, the other point, the bad faith throughout the process, that could be, I don't think that that is I'm not aware of a separate claim that that could fall under, but I do think it could be useful information and evidence to support other claims, like your discrimination claim, right? When you have things like, you're being scheduled for a meeting and you're being told the purpose of the meeting, and you get there and the actual purpose of the meeting is entirely in a different universe than what they said, and you're sort of being misled and no one's being, forthright with you, that can be potential evidence of discriminatory motivation, right? Or some non-legitimate motivation. Um, so that's kind of my view of the circumstances right now. Oh, okay. Do you know that other professor that you were just talking about? Do you know what their race or national origin is? Oh, okay. Yeah, right. Or like his national origin is some either Nordic or European centric origin, basically. It is, or like descent, based so to speak. But he is American. When you say he's American, you mean do you oh, okay. Okay. Do you know what his age is? If he's under 40? Okay. Um, yeah. So that do you know what department that tenured professor is in? The de Yeah, so I apologize. The department that he's in or was in that was being deactivated was it being deactivated or was it being eliminated? Okay. Yeah. When do you know when that was? When that okay. So that could be that now that is useful information. And now so that could signal that could provide more, stronger evidence of possible discrimination at play. Assuming you still need to figure out the individuals responsible for recommending or approving the deactivation approach um, are the same individuals, or at least there are the same individuals as those who are at issue here when it comes to your program deactivation. Um, you know, uh, but the additional information I will say is that is a lot more compelling of potential discrimination at play here. Right. I don't think that they need. I wouldn't think that. I would assume that the process, the deactivation slash elimination process, is the same regardless of what department is at play, right? So as long as that's the case, then I don't think it matters. I think as long as you have, program A, a year prior was set to be deactivated, the tenured professor there, who was a white American, tenured professor, was reassigned two courses and allowed to retain his employment, right? But then you had program B, your program. The tenured professor there was not treated differently, and the decisions were different with that. So that's, I think, it paints a clearer picture about what could be at play. But in terms of next, because I think that we need to we're gonna have to sort of conclude
Yeah.
here. I didn't realize what time it was. But in terms of deadlines, right now, I don't think that you guys. I can't think of any sort of 30-day deadline that you guys would be uh, looking at. Um, the when it comes to discrimination, you would have I mean at least 300 you would have 300 days to file a charge with the Nevada Equal Rights Commission from the
Right.
date of the discriminatory act.
Right.
So you are totally within the timing on that. 1983 and breach of contract claims are, I mean, they're breach of contract, I think, is about 6 years. I would
6 years. Yeah, it's
yeah,
6 years. 1983, I can't remember because 1983, one of the things you can do with 1983 is incorporate 1981. There's a Ninth Circuit case on that. You can use as the source of law, Section 1981, race discrimination. That has a 4-year statute, but I don't know if 1983 has something less, but it's at least 2 years.
I think from my recollection, I would need to confirm, but I believe the 1983 statute of limitations is uh, either 2 years or 3 years, but then depending on what state you're working in,
Yeah.
it'll track whatever the limitations period of the claim that you're bringing in that state, is
Right.
what I
So,
understand.
yeah, but it gets tricky because historically they like to use the statute for personal injury cases, which is 2 years, but
Yeah.
but Nevada is more specifically for any statutory claims is 3 years.
Okay.
So there's a little ambiguity there, but yeah, plenty of time here. So not anything that I can see that we're up against a deadline on. The INSHE code, we're gonna have to look back at that specifically. I know my recollection is that they claim that they adopted it by regulation or rulemaking such that it has force of law.
Okay.
So at least that's their contention, is that it has some sort of force of law. Of course, if we've got federal statutes that it's not consistent with, then we're going to have preemption issues. It's not very cut and dry. There's a lot of ins and outs in this that will have to be looked at more carefully.
Yeah. But in terms of like immediate next steps for us, looking for and sending over any uh, employment agreements or employment contracts or
Yeah.
documentation that's been executed since starting employment in January 22. Honestly, I would send over any sort of onboarding documents that you submitted, any employment related documents that you've signed or executed or submitted that relate to employment terms, you know, reemployment, for a given year, things like that. And send that over to us so that we can take a look at it. And
Yeah.
then once we're able to take a look at that, we'll confer amongst ourselves. We may have additional questions after looking at that. And if we do, we will let you guys know. But outside of that, depending on when we're able to see those additional documents, we will discuss
Yeah.
your case and the potential causes of action that you might have available. And then we will make a decision about whether or not representation is something that we're in a position to offer. Or if not, why in particular we may not be in a position to offer representation, which can go into a variety of factors, and it is not merits of a case is just one of many factors that goes into a decision on representation. Other factors like current workload, the cost benefit of investing in fees versus potential relief that you could be getting. All sorts of stuff goes into that, which, we will explain in any sort of follow-up decision on that. Okay. So if you guys have any other questions, feel free to send those to the email that you've been communicating with for the consultation process, and just tell them that these are questions for JP and myself, and they will share those with us. And we will do our best to answer those as soon as possible, but at the very least, when we circle back with you about next steps, we will answer those questions for you. Okay.
No, not at this time. I think AJ's right. We're going to want to look at those documents and um, figure out what might be the best direction. Yeah.
Great. Oh, okay. Great.
You
Absolutely.
bet.
We'll be on the
All right.
lookout for those documents, and we'll circle back with you guys, okay? So I think that we use a site called Box. That's the site that we use for documents, our own cloud protected cloud server that we use. So any documents you want us to see, you should either I believe you should have gotten a link to upload those documents, or someone should have been in communication with you about how to upload those documents. So I would just, yeah, do it the same exact way that you did for all the other documents that you've uploaded. Okay. All right. Thank you, guys.
Bye now.